Members, I don't have a gun. I don't have a permit to carry a gun. I would never allow a gun in my house, nor would my husband. I don't think it's a good idea. But I do care very much about your constitutional rights and mine. I care very much that the Constitution says that we have a right to bear arms as citizens and residents of the United States. The Second Amendment clearly says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And there can be all kinds of examples of cases that are brought here, but nothing will convince me that the Second Amendment should be anything but a meaningful right. And that's what this bill is about. It's about protecting a meaningful application of the right to bear arms. Members, you shouldn't look at this as somehow secondary to our First Amendment right of free speech. It should be no less protected as any other right in the Constitution. This takes us right back to the whole premise of our entire government, which is self-government, and the citizens are sovereign. We are the highest office holders in the nation. It's not the president, it's not the governor, it's not state senators, it's we the people, and we have reserved for ourselves the right to bear arms, and this is about making sure it's meaningful. I heard people say that this is legislation in search of a problem. I'm talking about meaningful now. I think that's what this legislation is intended to do, to make sure that that right is meaningful. This bill is not really about what happens in the exchange in the use of force. It's really about what happens in the court of law afterwards. This bill is about creating a presumption that a person can act in self-defense under certain limited circumstances when they defend themselves, when they are legally licensed to carry a gun outside of their home. I heard it said incorrectly that somebody illegally carrying a gun would be entitled to the rebuttable presumption. That is absolutely not correct. They would be entitled to claim self-defense and try and argue it in a court of law, but they would not be entitled to a rebuttable presumption. And that's what we're talking about now. A rebuttable presumption, all that means is that the prosecutor and the chief may have a little bit more work to do to prove that it was not an act of self-defense. And they are certainly capable of doing that in the right cases. I heard an example of Officer Mack. What a terrible tragedy that any law enforcement officer would be injured in the line of duty. Nobody more concerned about that than me, and I don't think anybody here in this chamber would take that lightly. But I did hear in that explanation from Senator Harrington that he believed that the shooter in that case knew or had reason to know that that was a law enforcement officer. That is the amendment that Senator Hoffman adopted today, and that would protect, in this case, the rebuttable presumption from being used in a case like that. Members, we should be able to trust our jurors. If there's a question, they can decide whether or not this was a reasonable use of self-defense. The county attorneys will be able to assemble the evidence if it's not. And I think it's fair to ask them to do that. The reason why? Law enforcement should never be threatened, nor should our county attorneys, by a resident's constitutional rights. We balance those rights all the time.